Got a question asking, when do you use a 3-day notice? What's the difference between a 3-day notice, 30-day notice, a 60-day notice? When are those appropriate? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Okay, so this is going to be like a 100,000-foot overview about what type of notices a landlord can use in a typical landlord-tenant situation. Okay, let's assume for purposes of this conversation, because there are tenancies that don't have rent or there's no exchange of value provided, a tenancy at will, for example, that requires different notice requirements. You got a landlord tenant relationship. You agreed to rent a space to a tenant basically, and they agreed to pay you rent. Okay. So we'll talk about those relationships. Okay. With those types of relationships, if the tenant does something wrong, for example, in your agreement, such as not pay your rent, or if you have a written rental agreement and the tenant is violating some type of material term of the lease, such as, you're not picking up your trash or you're causing a nuisance, that type of deal, 3-day notices can be used to address those situations. There's 3 common types of 3-day notices used in California under Code of Civil Procedure section 1161. Okay, they're the non-payment of rent notices, which are covered under 1161 subdivision 2. That governs all the rules about non-payment of rent. Then you have your 3-day notices to perform, governed under Code of Civil Procedure section 1161 subdivision 3. Those notices require usually that the landlord give a written notice to the tenant warning them, hey, if you continue to violate the agreement and so forth, etc., this material term of the agreement, you will be evicted. Okay. Some landlords covered under the Tenants Protection Act have to do 2 3-day notices. They have to do a warning 3-day notice, warning the tenants, say, you got to stop, cease and desist your lease violation. If not, we're going to give you 3-day to quit. Okay. That's a video for a different day. Okay. Or look at your other videos for that. Excuse me. Can't talk. Then you have the class of 3-day notices that are used to basically tell a tenant, hey, you're evicting them, or telling them they have to leave for nuisance and they have no right to fix that violation. Those would be 3-day notices for nuisance behavior, that the tenant is continuing to be a nuisance, they are using the property for an unlawful purpose, or committing crimes on the property. The Code of Civil Procedure kind of lumps those all together. And then there is one type of eviction in there that you have to have a lease term about, and it's what we call waste. Basically, it's a tenant basically using the property and causing like material damage to the property that is like not like it's permanent to the property. Okay, and you may be able to do an eviction without giving the tenant notice to fix that issue for waste. Okay, not going to get into the details of that. So those are the 3-day notices. Okay. And then the 30-day or 60-day notices, for example, would most likely be used to end what we call in legalese a periodic tenancy, which is a tenancy that doesn't have a definite term. Okay, like you have your standard 1-year lease. It basically says you move in January 1st of this year to the December 31st, 2025, for example. That's a fixed lease. Okay, any lease that has a definite start date and end date is what we call a fixed term lease. Other tenancies, such as if you go month to month, or the rental agreement says, hey, it's a month to month agreement, or, after your initial lease term, you continue month to month under the civil code. That's what we call an indefinite tenancy or a periodic tenancy. Okay. And you might have to use a 30 or 60-day notice under civil code section 1946 and 1946.1. And 1946.1 states if it's a residential tenancy that's, month to month or whatever it is, you have to minimum give at least 60 days notice. Okay. Tenants, if they want to end that, generally speaking, if it's a month, if you go month to month, you have to give 30 days notice under the law, or whatever period of time that's in the tenancy. So if you go week by week or day by day, you have to give minimum at least the length of time basically the tenancy is for. Okay. That being said, some landlords might need just cause to terminate a month-to-month tenancy under the Tenants Protection Act. Not going to cover that in this video today, but those are kind of a breakdown of what the difference is between the 3-day notices and the 30, 60-day notices. Think 3-day notice is something that the tenant did something wrong, and 30, 60-day notice is like just ending a periodic tenancy or a month-to-month tenancy and just going, you know what, I'm going to, give you 60 days notice. We're ending the tenancy, and at this point. And some landlords don't have to state a reason, but some landlords under the Tenants Protection Act have to give a legal reason to end that relationship. So your mileage may vary. Landlords, if you are a landlord contemplating terminating a tenancy and you don't know if you're going to be subject to Tenants Protection Act or local eviction rules, or don't know what type of notice to use, and you're in the Northern California area, feel free to reach out to our profile. Go to our website. You can book a case review session. There's a couple of questions that will ask if we're a good fit or not, and we can see if we can help you out. Put your comments, questions down below. Until next time, folks, I'll talk to you then. Thanks.